Right. You got this? All right. Welcome to First Amendment Day. This is the second of our day-long series of events. We're going to have an ethics debate, and I'm going to bring up the Director of Undergraduate Studies for the Parr Center, who's going to explain the ground rules and how this is going to go. I am Dr. Amanda Reed. I teach media law here at the J School. And so Vanessa, come on up and explain to us what we're about to experience. Thank you.
Thank you so much. All right, so as Dr. Reed mentioned, I am Vanessa Moore, and I work with undergrads at our Center for Ethics. For those of you who don't know us, we are located over in Caldwell Hall, part of the philosophy department here at UNC. So to give you a picture of who these folks are, these are members of the Intercollegiate Ethics Bowl team here at UNC. This ethics bowl is sponsored, or the larger organization is sponsored by AFI, which is the Association for Practical and Professional Ethics. And so it's university level teams who will debate ethical issues and approaches to them. And just a note about this team, they actually won the national championships of this event last year. Woo! So we are super proud of them and all of the effort and work that they've put into doing this. They are going into their first regional competition coming up in November. So we will keep our eyes on them and see how they do at that. Just to introduce everybody, this is Marley, Gracie, Swagat, and Taylor. And excuse me. Yeah, so just to give you a little bit more of an idea of what the ethics bowl cases are that they work with. They're real world ethical scenarios. There's a case set full of them that students work with every year. And the students, it's a little bit like speech and debate, but it's more working to debate approaches to debating approaches to solving ethical issues and discussing them constructively with other people who might have different opinions. The preparation for this is pretty extensive. It involves a lot of research, writing, understanding background ethical theories and oral presentation skills. So the case studies that they work with are intended to address those ethical issues. And today's debate topic is titled Speaking Out Against Speaking Out. And the case is focusing on whether a romantic partner must comply with the terms of a non-disclosure agreement that was signed at the outset of the relationship. And I'm going to ask Taylor to give a few more details about the case in just a moment, but the way that this generally works is typically this would be done with two cases and each team would have the chance to do the initial argument. Today, we're working with just one case, so Team A will give their argument, Team B will give comments, suggestions, reactions to that argument, and then Team A will give a response to that. And then we'll follow with a Q&A from the audience, and it can really be about any questions you might have about the case itself, about Ethics Bowl, and how any of this works is totally acceptable. So I will turn it over now to Taylor to just give a brief overview of this case, and we'll get going.
Right. Hello, everybody. So this case is about a woman named, well, it's based on a case of a woman named Erica Herman. And basically she was an ex-partner of Tiger Woods. And before the onset of the relationship, she signed an NDA, which is pretty standard for celebrity relationships. And at the time of their breakup or the ending of their relationship, she claimed that the inclusion of the NDA was no longer valid because she underwent sexual harassment. And when they broke up, she was also kicked out of their home. And so she said that the terms in which she was given residence were only due to like a sexual relationship, that their relationship was apparently transactional. So this case is essentially about the ethics of NDAs and whether they can really speak to future events. And whether signing an NDA can really cover all the possible things that a victim may incur and not be able to speak out on, because they're unaware of what's going to happen in the future. So it's also talking about power balances and just the overall ability, like at what point do NDAs become unethical, essentially?
So we'll get started with our presentation. Usually there's a moderator who asks us a question. Luckily, we've written our own question this time. So we're responding to a question we wrote. Typically our presentation will be 10 minutes. We'll be the presenting team, then they'll ask us questions. And we'll get started right now. I'll ask the question as though I'm the moderator. Are NDAs ethical due to their job to hide information, possibly including information that implicate moral wrongdoing? Our answer to this central moral question is that while NDAs in general are permissible, they're unethical between interpersonal relationships. So in this case, an interpersonal relationship would be an NDA between two individuals, as opposed to between an individual and intellectual property, typically like a corporate NDA. So in the case of Tiger Woods, the existence of the NDA at all, we're arguing wasn't ethical. So the first argument we're using to ground this is that NDAs often impose free will in a manner that violates the harm principle. So the principle of harm and autonomy holds that one's autonomy stops at the tip of someone else's nose. So essentially that autonomy should only be impeded on if there's a harm being had. So my autonomy stops when I'm harming you. And often this occurs too when my autonomy could cause me to harm myself. Think about seatbelt laws. I'm giving up a little bit of autonomy to prevent harm to oneself. However, an NDA is stopping harm from being protected, prevented, or like undone. And this doesn't fall within the moral framework of when autonomy should be impeded on. So someone's will to say, this person has harmed me, or this person has done something that's incredibly morally wrong, has been prevented using an NDA, but there's no moral framework explaining why it's okay to prevent someone from preventing harm. That's sort of the name of the case, speaking out against not speaking out. And it's a little implicit, it's kind of subliminal, but we shouldn't set the precedent that someone can sign away the right to prevent harm to themselves, especially in a sort of contract that is imbalanced inherently. And so that gets into our second point, which is that a contract should never allow for abuse that makes them inherently imbalanced. Contract theory holds that moral principles and actions can be decided between parties. So if I turn to Taylor and say, I'm going to stop talking in the next 3 minutes, and you're going to talk, we agree. So I'm going to stop talking, I give up my right to speak forever, and then Taylor's going to start talking. That would be a contract between us, a social contract, sports. They're balanced, we mutually agreed. However, a contract like an NDA that says you can't talk about me abusing you is inherently imbalancing that contract. There seems to be something muddy about the mutualism between that. They usually have a problematic power imbalance. Oftentimes, an NDA is being signed by someone with more resources. They're saying if you sign this, you'll have access to these resources, like money and experiences and general ideas. In the case of Tiger Woods, she was provided a place of residence. We have the opportunity to set a moral framework that completely disallows for a contract to allow for abuse. We shouldn't let that be something that people can mutually agree upon. We can consider that to be a morally binding.
Our last point that we'd like to make is about how society is intrinsically worse off if we allow this harm to occur without it being brought to light. Many NDAs, specifically interpersonal ones that involve these two private parties, only one of them is sworn to silence, whereas the other one is able to maintain this power. And this inherently limits one's ability to discuss any misconduct that may have incurred while they were under the rules set by the NDA. Any NDA that is able to cover up illegal activity, it's still technically legal, but they're setting up a barrier that we can't enforce this kind of wrongdoing. So this can be enforced, so this can be supported by John Stuart Mill's dead dogma theory, which pertains to opinions, but holds with any socially upheld truth. If no one is able to present evidence that Tiger Woods may not be a good person or may have sexually harassed his ex-partner, we will use his goodness we will believe that to be the truth. So the dead dogma basically holds that we should constantly question the ideals and morals and opinions of these people so as to not let them be cemented as an unquestionable truth, which is what a dogma is. If we are accepting these truths that are negated by contradictory actions, or at the very least, we are questioning them, they will inevitably affect us without us seeing them, and thus be able to change the way that society runs, how we maintain morals and laws and everything else that protects victims in our society.
So in conclusion, we've argued that interpersonal NDAs are impermissible because they violate the harm principle. They impose free will in a way that prevents people from stopping harm to themselves. We argue that there should never be a contract which allows for abuse, that it's never binding in that case, and that society is worse off when we allow harm to happen in the dark. We should be able to question people and ideals in a way that mitigates harm, not that enforces it. Thank you.
Great, thank you so much for your presentation. Really appreciate it. Really interested in going into more depth about how we can exchange our argument potentially. So I do concede and agree that NDAs are not always the best idea, but I also am questioning, why are they permissible even at all? So I'm asking this question because you guys have a partial argument currently. So obviously we recognize the benefit of intellectual property being protected. We understand that innovation is helpful and it takes time, so we don't want people to be able to take that from other people. However, we ought to have, and like, yes, we should have protection over it, but just because they're permissible in that way doesn't mean that they're exactly ideal. So I am wondering maybe why you guys chose to take this partial argument instead of just, deciding like, no, NDAs should not be okay. It's hard to it's hard that if an NDA could have this possibility, then we shouldn't have NDAs at all. Another question that I was wondering is, so NDAs are mutual agreements, meaning that you don't have to sign them at all. So this is obviously in contrast to what I previously said, but because they are mutual agreements, and you don't have to sign them, that to mean that NDAs should be permissible in some ways because Erica Herman chose to sign that NDA, even though she was an employee at the time. She chose to do that. And just because we need to be cautious of this balance of life, remember that they are signing off on their right to do something. And because she chose to do it, that inherently makes it that it was mutual. And so maybe they should be permissible in that way because she had the autonomy to do that.
And furthermore, why not have an NDA? If you're going to have an NDA, why not explicitly disallow for any sort of misconduct to be protected? For example, why not have a clause in the NDA that Erica signed, which disallowed for this sort of exploitation to occur? We should amend a good thing rather than categorize it as a bad thing. And celebrities also need this sort of protection as much as we would like to think that they are the same as everyday people and that they don't need an NDA. They aren't the same as everyday people, and they have reputations to protect and brands to protect. Therefore, they need NDAs. And we left it handed that to them.
So to answer your first question about why NDAs should be permissible at all, that's a good point. We've outlined really compelling reasons as to why they shouldn't be, but we hold that NDAs in general can do a good thing in protecting intellectual property. we're generally sympathetic to the fact that innovation is like a good thing. And that NDAs and the time that it takes to develop a good idea, protect that idea from being swept out from someone. But we're a lot more partial to NDAs protecting someone else from harm. So we've outlined a case of NDAs that are kind of allowing someone to do a bad thing in secret. But what about cases where a bad thing has occurred in someone's life, namely, as you pointed out, a celebrity, and they don't want that to go public? I think about cases where a celebrity couple has gotten a divorce and all of their kids have access to the internet. It would be wrong for someone in that person's life to go public with that. So an NDA would stop them from doing that. Because maybe they don't want their children to see a lot of discourse over their own divorce. In situations like that, where an NDA is permissible because it's stopping harm from occurring, and we don't think that they're ambiguous. We think it's very clear in differences between documents as to what people are and aren't allowed to say. If an NDA were to say, you can't talk about a divorce, or if I abused my wife, well, that would bind it. But just to say that we think that we should have some level of privacy in our lives is fair and something that every person is owed, even if they're a celebrity.
And then I'd like to address the question that you asked about NDAs being mutual agreement. And we agree they are a mutual agreement, but the difference between an NDA versus a regular contract, as Marley pointed out earlier, there's a power imbalance and it's not mutually beneficial for both parties. If all that stands between an increased quality of life and not being open about this harm that has incurred to this person, someone is more likely to choose the benefits because they're unaware of these harms that have not yet occurred to them. So in the position of somebody signing an NDA, such as Erica was, she was unaware both that she would start a relationship with Tiger Woods and that she would become homeless after that relationship ended. And this was all knowledge that she was not able to have at the time when she signed it, but it was still power that he was able to have, both the power to form that relationship with her as he did as her employer, as well as the power to kick her out of his home whenever he saw fit. And it's this power imbalance that made that NDA unethical. And we should remember that individuals signing NDAs are signing off their rights to act in a situation that is yet to happen. They're signing away their right to free speech about a situation that they do not know has occurred. It's very hard to say that they've given informed consent when they do not know the full terms with which they are signing this contract.
Yeah, so another question you guys asked, I think a really good question, is why not have an NDA that explicitly disallows for misconduct to happen? Rather than say they shouldn't exist at all, is it not possible to just put in, like, an NDA cannot exist if it allows for misconduct? And we want to point out the fact that this is actually generally already true. If an NDA, it shouldn't protect legal activity. It's not binding if it protects legal activity. I don't know if anyone signed a waiver at like a trampoline park and someone said, oh, that's not actually binding. Like, it's not a legally binding document. But because you signed the waiver, you're going to act in a way as though it is. There's no lawyer telling you that it's not a legally binding document. So even though it's ideal to just make a perfect version of an NDA, I think that we have to be a bit practical in the fact that if someone has something to hide, they'll make sure it gets hidden. And an NDA is a really good way of doing that. They usually use very loose, broad legal jargon and really bad consequences. Like if you break this NDA, for example, you're not going to have a house anymore. They didn't say that in the NDA agreement, but it's these sorts of consequences that motivate people to follow them. And so we don't want to present a situation that's ideal, but completely impossible to happen. And that's why we think that we should hold interpersonal NDAs to be wrong at all. We also want to caution against the idea that trust can't be built between individuals naturally. It shouldn't necessarily take a legally binding document for you not to share sensitive information about someone. And then if that trust is broken, i.e. via like abuse or some sort of misconduct in that relationship, you don't necessarily have to uphold the stipulations of like not going public. And so we know that NDAs are important legally and morally, but we also think that trust is a little bit more important morally. And we should lean on the side of trusting people as opposed to having documents that give really broad outlines as to why we shouldn't trust. And with that, we conclude.
Now feel free to ask us any questions you have. Anything and everything is open for us to interpret.
Is the case saying what's like circumstance the NDA was signed, because you said he was employer and she was employee? Should it have changed when their relationship sort of changed from that dynamic to partner? Or I don't know, I don't really know.
I would say that ideally it probably should have changed. Just because it's a very different circumstance than being employer and being partners. So ideally it should have, but unfortunately I don't believe it did at all, which is why there was this problem and why the Speak Out Act was passed in the first place. I don't know if we discussed Speak Out Act, but maybe that's.
Yeah, the fact that this harm encouraged her under the pretense of a relationship, wasn't set at all under the original NDA she signed. And that's kind of the point we were trying to make with these interpersonal NDAs being unethical, because they really can't account for the kinds of changes that occur. Like, she didn't know that he was going to provide her with her home. I mean, and that she would lose it if they were to break up. When she signed it, she was under the pretense of being his employee.
Yeah, and the terms didn't change. And typically, this kind of goes back to the idea of if someone has something to hide, they'll make sure it's hidden. If she signed an NDA that was under the stipulation that they were employer and employee, it's not going to change, especially if he has so much power over her, she's not going to say it. I think we need to go back over our NDA. It's just going to stay the same. And we wanted to also talk a little bit about the Speak Out Act, which was passed in 2022. And it says that a non-disclosure agreement can't be enforced in a situation of sexual misconduct, which is exactly what we're saying shouldn't happen. The only problem is that people are still not speaking out about their experiences because of NDAs. And it's hard because we keep saying NDA as a word, but it really is a legally binding document that makes someone feel like they cannot say something, even if the law says you can. It's not just a legal framework, but kind of just like a feeling that there's going to be repercussions if I speak out about this. So the Speak Out Act is doing what we're saying, but it's still preventing people from speaking out, which is why we think in any interpersonal relationship, there shouldn't be an NDA unless it's merely to protect private information about that person's life.
You guys talked about that celebrities are the people that usually need NDAs, and can normal people that aren't celebrities have NDAs? And I guess if not, it's just a celebrity thing, what constitutes someone as a celebrity to be able to have an NDA?
I would say that the argument that we're trying to make is that for any interpersonal relationships, like normal person, celebrity, they shouldn't have NDAs, unless it's specifically to protect private information. But with that being said, with trying to protect someone's intellectual property, it can be said that an average person like you or me could have an NDA. For example, if someone was developing an app, and let's say that they were working with maybe they've not developed any app before, they're in college, whatever, and they're working maybe with a team of people, and they decide, well, I don't want any of these people to get a jump on me on this app, so I might make them sign an NDA to ensure that before I can secure a patent or get this app on the market, that my intellectual property is not stolen. So I would say that there are circumstances in which an average person should be able to have access to this. It's just in the case where it can cause undue harm unto another, which usually happens in the cases of interpersonal relationships. That's when that's when it becomes an issue.
Yeah, to answer your second question about what defines someone as a celebrity, we would think anyone whose life is up to public scrutiny. So I've never met this person before, and I know enough about them to get a gauge of if they're a good or bad person, like Tiger Woods, for example. And yeah, like I know the Daily Tar Heel, they have to sign an NDA, because something that we didn't explain is that there's multiple types. So there's unilateral, where only one person is saying that they won't disclose something, and then there's multilateral, where a large group of people are agreeing not to talk about something or not to disclose something that they discussed. And in that scenario, the average person can do that, like a student publication can do that, and Fox and CNN. Yeah, and the honor court really cannot say anything about like their cases, or couldn't. And so, in those situations, like there doesn't even have to be a celebrity involved. It can just be organizational. So they're really wide, they have a really wide scope.
Would you say then that if there is an NDA purely for privacy reasons in your personal relationship, that then both parties should have to agree to uphold privacy? For example, Tiger Woods should have been held to the same standard as Eric.
I mean, ideally, yes, but I think that it's so difficult for that to be the case, because he ultimately does have significantly more power than she does in this relationship. So even if they are held to the same standards in the signing of the document, there's still that power imbalance. If anyone else has any comments.
Especially because, I mean, he is like world famous. He has a lot more fame, money, all of those things over Erica Herman in this situation. So yeah, I would say I agree, like the power balance is what the problem is. And so I think in a personal relationship, if it was me and someone else, obviously I'm not famous and I probably wouldn't be with someone famous either. So like, if it was a personal thing, then I think that yes, hopefully that could be upheld. And ideally in this situation, if they had both had just been like non-celebrities, then yeah, that could have been upheld. But because he had such a higher power over her, that's why. And also because, you know, she lived in his house and she was his employer, and or he was her employer. And so like all of those reasons made it very difficult in this situation, for them to have had that like privacy back and forth no matter what. And also because, according to her allegation, like in this situation, like he sexually harassed her and he did not like say anything back about that either. So I'll also say that I don't think any of us have read the exact NDA. But so we're not exactly sure, but it's unlikely just because of the amount of power.
I'd quickly add, it's just that there's value in the fact that if he signed it, maybe she'd be less afraid of social repercussion. So maybe there's things he can't say about her. So a lot of the time people are afraid they'll go back and say something about them. The only thing is that we don't want to manufacture like reciprocity. So in a relationship, generally, you should not have something looming over your head that if I say something about Gracie, she's going to say something about me. And that's what keeps our friendship together. Like that would be kind of odd and doesn't seem like to support or sustain a healthy relationship. So like ideally, legally, yes, but again, morally, no. We'd want to like kind of err on the side of caution of like making mutual relationships into legal law.
I'm curious about how you all are thinking about the harm, whether the harm is the homelessness, right, being evicted from the home that she lived in with Tiger Woods, or whether the harm is being unable to speak about what she experienced during those relationships, whether you all are thinking of those as kind of the same thing, or whether you separate those out and think of maybe the speech harm differently than you think of the housing related harm.
I would start to say that the speech harm and housing related harm are different. Thinking about bodily harm versus maybe like, I don't want to say intellectual, but it's just physical versus non-physical harm. Being unhoused is like actively harmful. Getting kicked out of your house. I want to say it was Hawaii. Actively put you in a position where you're vulnerable to the elements. You don't have a place to stay. You're vulnerable to anyone who notices that you don't have a place to stay and you're frantic. Whereas the speech harm feels even like a bit, like you said, it's different and it's hard to explain why it's different, but it's stopping someone's own free will. And in general, I think all of us enjoy having free will. And the act of not being able to speak out against something that is bad, I think makes you feel A, confined, and B, it makes you feel like that harm will always be able to be done to you. And so it's like the harm of an actual physical harm, and then the mental, that's a good word, the mental and emotional harm of not knowing how to make it stop. And so it kind of creates this really vicious cycle.
I think you did a great job summing that up.
You guys want to ask each other any more questions?
I have a question, but not about the case, more about how these debates usually work. And if, like, I assume you had both prepared, but I don't know, like, did you prepare when you were gonna refute? And like, how does that work usually when you both on two different cases? Have you read the case before? Do you have a?
I can go ahead and say, so this case specifically is one of our cases for our regional case set this year. So we've all read this case, gone over it, and Marley was gracious enough to write us up a little case outline. Most of the things that they were saying and we were saying were kind of more off the top of the dome, but key points of like things that we wanted to hit on. In a normal case round, basically what would occur is that there's 5 or 6 of us. We have 2 different teams this year. And basically we all have case write-ups that we memorize. So we each write 3 to 4 case write-ups, and then we memorize them for regionals. So during that, we have like an introduction person, 2 arguments, a person that does objections, and a conclusion. And so throughout the round, we have 10 minutes to present, and then the other team has 5 minutes to like give like objections to us or like rebuttals. And then we have 5 minutes to go back and say like, well, actually, this is like what we meant, or this is how we clarify that. And so normally, like, if we were in an actual round, like at regionals, we would have no idea what the other team is gonna say, and we would not have any idea what the question would be either. So we like try and like hope we would know what the question was, but like, it's really just like, okay, that's the question. We have 2 minutes to confer, and here's 10 minutes of our presentation that we know, like, hopefully have like something we can come from with everything that we've like researched and done for the case.
And usually, like Gracie was saying, we don't have anything actually prepared. One addition is that when we present, we usually include the alternate perspectives or objections. So the questions they ask typically would have been questions we kind of like ask ourselves.
We would have addressed that.
Yeah. Because I think something, I don't know if you mentioned that ethics poll, you don't have to disagree with the person. It's the winner is who has like the most thorough ethical conversation. And so it works in your favor to bring up counter arguments yourself and address, like with fidelity, address why you didn't talk about them. And so usually that would happen, and they would confer amongst themselves, and we usually rapidly be taking notes to ask questions to the other team. We just had this prepared this time, so you didn't have to see us with our nose in a notebook.
Yeah, no, it's about creating nuance to the discussion more so than debating anything. The most important thing is that we get to have a good conversation about these ethical topics, these really interesting cases. I mean, they're so fun every year to read these and think about them and talk about them. And it's in a competition, we're basically just having a discussion with another team and getting to hear what they think, getting to ask them questions, to learn more about their argument. And yeah, we don't like to think of it as like debate or anything. It's more like this, where we're just basically having a conversation.
To add to what she said, by the way, it's about nuance. You don't want to have your position be too nuanced. You want to have like a hard position instead of like a Goldilocks sort of position, and then like back it up with very thorough arguments.
You said this is the case you have for your regional competition, so how far in advance do you usually get your cases? And also, like, how do you really prepare for these competitions, and it just like researching or like do like past practices of like debate that sort of.
24/7. Yeah, we do, so we got this case set like the week after Labor Day weekend. And then we have until November to prepare, and it's exactly what you said, every practice, we just debate. We do like a mock round. Each practice, so there's 2 teams, 5 or 6 in one team and 5 in the other, and we debate with each other. It says debate, it's really, again, like a conversation. We critique ourselves, try and improve it for the next practice, and then we do that until November. And we usually have the help of, we had a coach last year and he's still helping out this year, grad students, people like Vanessa, who will come in and like judge around for us. Something that you guys basically did, where you were the judges. Usually there's 10 minutes of judges questions that are really hard to prepare for because they're like philosophy nerds, and they also have niches and things that you would never guess. Like there would be a First Amendment judge for this case just by pure luck. And so it's helpful to have like experts, and that's helpful.
Yeah, if you guys are ever interested in sitting in on a case and asking us questions, please do not be afraid to email either Vanessa or Marley, because Marley's one of our co-execs. So we love having guest judges, and we love getting as many people to ask us questions as possible. We love the nuance, so just putting that out there if anyone wants to be stoked.
Any last questions? Well, please join me in thanking our award-winning, tell about the awards. Where did you win awards last year?
We won our nationals.
Yes.
So the
Where in the world was that?
Georgia, Mid-Atlantic region,
Sounds
Georgia
fun. That sounds
in
fun.
America. And then we proceeded to go to nationals, and then we won nationals undefeated.
Excellent. Please join my award-winning team for their time and expertise. Event for our day-long series is on the steps of Manning Hall, Sills, where there's going to be a banned books reading. So we're going to have a book carol with a bunch of books that have been banned or challenged, and people will be able to pick their preferred book and read out loud. And there's going to be amplification, so some kind of recording or microphone where you get to read aloud a spicy book. So know that that's coming up next. We've got a webinar for those who are not able to come to campus events. Then there will be a 2 o'clock, a 3 o'clock, a trivia, and then a keynote at the end, and there will be dinner before the keynote. Good? All right. Thank you so much. Go team.